May it please the Court, I'd like to reserve 2 minutes for rebuttal. Rebecca Creed on behalf of the appellant, lessee Leon Brooks. This is the second appeal in this case. On this appeal, Mr. Brooks appeals the trial court's revised final judgment entered after this court's opinion and mandate in the original Brooks opinion. In that original Brooks opinion, this court reversed the damages for judgment, the judgment for damages against Mr. Brooks, and remanded with instructions that the trial court order specific performance of the option to purchase found in the parties' lease agreement. On remand, the trial court did grant and order specific performance of that contract. However, it did so with one important exception. It required Mr. Brooks, as the purchaser of that real property, to assume the responsibility for satisfying a lien that had since been imposed against the land, which was then owned and remained owned by Mr. Green, the seller, by the City of Panama City's Code Enforcement Board. This lien was a lien against the land, and it was imposed at a time when Mr. Brooks had no right to ownership, possession, or control of that property. More importantly, the trial court disregarded the plain language of the parties' option contracts, which it found were valid and enforceable. Specifically, the trial court found in its order that the lease option, or the option to purchase found in the lease agreement, contemplated that Mr. Brooks had the right to draft the purchase contract, and that that purchase contract, as drafted, signed, and delivered by Mr. Brooks, required a warranty deed, clear title, and title insurance. Aside from this express obligation to convey clear title, the trial court further found in its order that there was also an implied obligation to convey clear title as a question under Florida law. Under Florida law, because it was a contract to convey real property, there was an implied obligation for the seller, Mr. Green, to convey clear title to the buyer.
Counsel, let me ask a question. Under the lease, the lessee is required to pay all taxes relating to the property. Hypothetically, let's assume the lessee failed to pay the ad valorem taxes, and as a result, there was a lien placed on the property. Would you argue that the obligation to provide clean title would require the landlord to pay those taxes?
Well, in fact, that was the question as to the unpaid ad valorem taxes was before the trial court.
The issue here has to do with the lien placed by the county for cleaning up after the fire, as I understand it.
That's correct, and it was a lien placed at a time in January 2007. The lessee, Mr. Brooks, had been evicted from that property.
The counsel had the proceedings for the Code Enforcement Board preceded the constructive eviction of the appellant.
Yes, they had, and those facts were all in evidence at the first trial. That the issues before the trial court at the first trial were all related to the Code Enforcement Board, the allegations that this lessee had committed waste and nuisance, and the same conduct was brought up in front of the trial court at that trial. The trial judge at that trial found that there was no breach of the lease agreement.
There was one important exception that wasn't there, counsel. The lien had been placed at the time that the trial court issued its final order.
The lien had not been placed. No, that's correct, but now that the seller's relying on the same course of conduct, and that conduct has already been adjudicated against the seller to find that there's no breach, that the lessee did not breach the lease agreement, did not commit any waste or nuisance, notwithstanding that this conduct may have occurred before the lien was imposed.
Counsel, isn't the law of the case doctrine, doesn't that suggest that we deal only with questions of law that were properly before the court in the prior proceeding? And how could this question of law have been before the trial court when the lien wasn't placed until after the final judgment was rendered?
While the lien wasn't placed, the same conduct was there. The lien only arose because the owner, the seller, failed to remedy the condition that had been created. The same facts were there. There were allegations of nuisance and waste between the date of the fire and the date that the lessee was evicted.
But notwithstanding that, when this case came before this court before, the question of law decided on appeal had nothing to do with breach of contract with regard to the waste. Is that correct?
That's correct. But if you look to the trial court, the first trial, those issues of nuisance and waste were allegations against the lessee, Mr. Brooks, there were allegations that he had breached the lease by failing to clean up the property after the fire. Excuse me.
Was the lease in effect when the building burned?
The lease was in effect, yes, when the building burned. There were allegations that he had breached the lease, tried at the first trial, and the only finding that the trial judge made as to the breach of the lease related to the fire insurance. The trial judge rejected any claim that Mr. Brooks had breached the lease by committing waste or nuisance. So at that point, the lessor had no claim against the lessee for the commission of the waste or nuisance. At that point, it had already been adjudicated. So it's not, and I realized in preparing for this that it's not just a question of law of the case. It's really res judicata, and that any finding that the condition as a result of the fire breached the lease has already been decided against the lessor. And that final judgment was appealed only by Mr. Brooks as to the fire insurance requirement. The seller never appealed the trial court's finding that there was no waste or nuisance. And in fact, this court, when it heard the case, reversed the finding as to any breach of the lease agreement and reversed the judgment of damages against.
Isn't it more correct, though, to suggest that this court found that there was no breach with regard to the issues that were before the court in that case?
In that
which
case.
regarded the insurance policy.
But implicit in that final judgment is not just a finding that there was a breach of the fire insurance, but also a rejection by the trial court as to any breach of the lease by the commission of waste or nuisance. That had been an issue that was raised in the lessor's counterclaim. That was found. The final judgment is silent as to that, grants no relief to the lessor on that claim, and therefore that adjudicates that claim against the lessor. He can't now come in and argue that a lien that was imposed when he was the owner of the property, at a time that's undisputed he was the owner, and that he was the only one who had the right to possess and control the property at that point. Again, the lien was entered in January 2007. The lessee, the buyer, had already been evicted as of that date. There was 6 months in between, and he had no ability at that point to remedy the condition. That responsibility remained the obligation of the owner, Mr. Green.
This court reversed the trial court, remanded the matter back to the trial court to order specific performance. Is that correct?
That's correct.
Now, when a trial court contemplates specific performance, the trial court must consider the facts of the case to achieve a fair and just result. Is that correct as well?
That's correct in part, Your Honor. I would agree. But also, I would urge the court to look to the question of what is to be specifically performed in this case is the option contract and the contract for the purchase of the real property. And there it's undisputed that the trial court found both that the seller had an obligation to convey clear legal title, both express and implied. The language of the contract that was sought to be enforced required the seller to convey clear legal title.
But didn't the lease require the lessee to keep the premises in good order and repair?
The lease did, Your Honor, but again, that claim had already been decided in favor of the buyer at that point.
Are you suggesting that when the court was fashioning a remedy of specific performance and can employ its equitable powers, it wasn't at liberty and didn't have discretion to consider this lien that had been placed subsequent to the court's prior judgment?
I would agree based on the plain language of the contract. Even in the case law is clear, even in cases of specific performance, the court must follow the plain language of the contract as written. And what this trial court has done is essentially vary the term because it deemed it to be a bad bargain. It looked at the facts and it said, I don't think this is equitable for this seller to have to pay this lien.
Was the res judicata or law of the case argued below?
Certainly, yes. Probably not in those words exactly, but I believe res judicata was to the extent that what counsel argued on behalf of the lessee was that you're basically now trying to go back and retry this case. And, you know, to the extent that the only claim was that this claim, to the extent there had been any allegations of nuisance, would have been one that would have been decided already against the seller.
Counsel, in reference to the first appeal, is there any other issue decided other than whether the lessee breached the agreement by failing to name the lessor or owner as an insured or loss payee on the fire insurance?
As to the first appeal?
That's correct.
The other issues raised related to whether that breach deprived the lessee of his ability to exercise the option. it did not, again, it didn't specifically address the waste or nuisance, but that claim had already been decided against the lessor, and he didn't cross-appeal to raise that issue. So for these reasons, I see I'm well into my
Counsel, I'll
time.
give you a minute to
Thank you.
rebuttal and add a minute to Mr. Hutto's time.
Thank you.
May it please the court, I'm Bill Hutto from Hutto and Bodiford for the lessor, the appellee, Jonathan Green. And as the court has correctly noticed, the lien that was filed in January of 2007, and the first final judgment was rendered by the court in July of 2006, some 6 months prior. So the lien was not in existence at the time. It was not a matter that was considered by the court at the first trial.
But the lien wasn't, but the responsibility of the lessee for the condition of the property was considered by the court, was it not?
It probably was to some degree, but see, the end result of the judge's judgment in that case was that my client was adjudicated entitled to receive the $400,000. If he got the $400,000, he'd been more than happy to clean up the debris. But what happened, we think that the cleanup obligation goes with money from the fire. So this court ultimately reversed the trial court, took away that $400,000 from my client, in effect, and gave it to Mr. Brooks. And this court found, from the record on appeal the first time, that the fire was a total loss, and that Mr. Brooks received the entire value of the burned building with the $400,000. And that's the reason Judge Overstreet, in the March 25th transcript, if you'll read it, he says that wouldn't it be stretching equity to allow Mr. Brooks now to keep the $400,000 and saddle Mr. Green with the obligation to clean up the debris that's now a lien on the property by the city. And he used the words, don't you think that would be stretching equity? Now, the specific performance is an equitable remedy. It was ordered by this court, but at that time there was not a lien. If it had been a lien, we might have had some argument about it at that time. It didn't exist. Now the lien exists. My client no longer has the $400,000. Mr. Brooks has the $400,000 from the total loss of the building, and still wants my client to pay to clean up the debris that he's been paid for. Or say been paid for. That amount is still in escrow, by the way. We've agreed to. We went ahead and had a close and left a lien in place, and set aside $50,000 or thereabout in escrow until this issue is resolved, as who is obligated to pay this lien. But the lien amount was $23,000 and change, plus there would be some interest running on it since then. But and it was on that prior decision, if you want to look, it's on page 62 and page 60 of the prior decision, where it was a finding that it was a total loss, and that my client was not entitled to the $400,000. Mr. Brooks was, and again, we believe that the cleanup obligation goes with the money, and that it's not equitable for him to receive the money and us be obligated to clean it up for a lien that did not exist when the case was initially tried.
In its ruling on whether or not the lessee committed waste to the property by, I guess, not cleaning it up, did the trial court address responsibility for the cleanup?
The trial court did not address responsibility in its final judgment.
In the first case?
In the first case. And then when the order came down for specific performance, we had 3 issues floating around, and we didn't know how to handle, because the lease agreement did not provide who is to pay what by way of closing costs. In other words, it didn't provide what kind of deed you're supposed to give, whether it be a warranted deed, a quitclaim deed. It didn't specify title insurance, and this lien had popped up too. And an example you raised, Judge, about what if from others that I've thought about. What if there's, in addition to a tax lien, what if there's a judgment against Mr. Brooks? What if there's a mechanics lien against Mr. Brooks that arose in the meantime? What if he had mortgaged his leasehold estate? If you adopt the appellate's argument here today, we would be obligated to pay all those things. And that's just simply not equitable.
I did think when I read the lease that it's unusual to give the lessee the right to prepare the purchase and sale agreement.
There's a lot of unusual things about that lease. I did not prepare it.
I wouldn't think so.
Any other questions? That's about all I've got. Thank you. One other thing, on the other point of appeal they've got is that it was preserved from the prior appeal, was they were asking the trial court for attorney fees to recover attorney fees, and they included an issue in the brief about that. And we stand on the State Farm Supreme Court 1993 State Farm case from the Supreme Court of Florida that's been on the book since then and has not been altered. It says you're not entitled to attorney fees to collect attorney fees. So.
Ms. Creed?
May it please the Court. First, the city's code enforcement lien is a lien against the land statute, and that lien remains the ultimate responsibility of the owner of the property. Again, at the time the lien was imposed, Mr. Brooks didn't own the property, and he had no ability to remedy the condition because he'd been evicted from the property 6 months before. There's no evidence, as the trial court even found, that the insurance proceeds cover the cost of removal. That was a fact that was essentially presupposed by the trial court with no evidence. And Florida law is clear that even in the context of specific performance, the contract that is to be compelled must be given its clear and plain meaning. Even in the context of specific performance where a court may weigh equities, there's no right to vary the express terms of that contract, even if the court may view that the parties may have made a bad bargain. What the trial court has done here is effectively unilaterally increase the option purchase price, which is contrary to this court's mandate, which directed that the option be enforced according to the option purchase provision in the lease agreement. And for all these reasons, we ask that this court reverse that part of the trial court's ruling that requires Mr. Brooks to satisfy the lien. Thank you.
Thank you, counsel. Thank you both. That completes our cases for the day.